Hello, I'm Paul Chudleigh. I'm a consultant solicitor with Bonallack and Bishop and head of the private client department. And one of the things I deal with is dealing with grants of probate and letters of administration, and this is just a simple explanation as to what that involves. First step you need to take is to find out if the deceased made a will. And usually the first port of call is the deceased's solicitors. But look through their personal papers, banks, and there are other avenues open if you can't find a will. If there is no will, then the deceased's estate is governed by what is known as the laws of intestacy. And the laws of intestacy determine who takes out the grant, usually the deceased's next of kin, and they become administrators, and they have the same functions as executors under a will, and both are called personal representatives. The first thing that needs to be done is to register the death with the local registry of births, deaths and marriages. And then you'll need to make funeral arrangements. The will sometimes contains directions as to what is to happen. But if not, then the family may know what the deceased's wishes were. The personal representatives are responsible for ascertaining the assets and liabilities of the estate. They have to go through the deceased's personal papers, and it is a fairly onerous task because HMRC impose penalties if they feel that personal representatives hasn't applied due diligence and made a thorough investigation. A grant of probate or a grant of letters of administration is the title or right of the personal representative to deal with the deceased's assets. Not always. There are cases where if a property is owned jointly, the share of the deceased may automatically pass to the survivor. There are also cases where estates are very small and the bank or building society where the deceased had savings will accept a declaration made by the personal representative rather than going for a full grant of probate.